Welcome to literary and jury charge practice. Let's start out with some literary. Ready? Here we go. It is your duty to decide the questions of fact in this case. It is my duty to give you the rules of law you must apply in arriving at your verdict. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence you have heard and seen in this trial, and you must disregard anything you may have heard or seen elsewhere about this case. I have not, by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or the outcome of this case. If I have said or done anything that would seem to indicate such an opinion, you are to disregard it. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until the defendant has been proven guilty beyond a reasonable doubt. That the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you as in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove innocence. Proof beyond a reasonable doubt is such proof as ordinary, prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. In order for you to return a verdict, whether guilty or not guilty, each juror must agree with that verdict. Your verdict must be unanimous. You should discuss the case with one another and deliberate with a view toward reaching agreement, if you can do so without violating your individual judgment. You should decide the case for yourself, but only after you have discussed the case with your fellow jurors and have carefully considered their views. You should not hesitate to re-examine your views and change your opinion if you become convinced they are erroneous, but you should not surrender your honest opinion simply because other jurors disregard or merely to reach a verdict. A fact may be proven by either direct or circumstantial evidence, or by both. The law does not prefer one form of evidence over the other. All right, we will stop there for now. And let's see what we have for some literary practice. This is called Stick to a schedule. Ready? Here we go. A well-maintained vehicle delivers stronger and more efficient performance. Each belt, fluid, and part has a purpose, so keeping them all up to par is the best way to avoid a breakdown and costly repairs. In some cases, improper vehicle maintenance may void certain manufacturers' warranties. What's more, when it comes time to replace your vehicle, a documented maintenance history can contribute to a higher resale value. Familiarize yourself with the maintenance schedule outlined in your vehicle owner's manual and prepare for these standard costs. Most late model cars are equipped with computerized maintenance reminder systems set by the vehicle manufacturer. Don't ignore the indicator lights messages that pop up on your dashboard. Doing so could increase engine wear and potentially cause major damage. Your owner's manual should also provide estimated schedules for infrequent services, for example, replacing the timing belt, brake pads, or tires. You may save time and money if you plan ahead and combine these services into one maintenance appointment. All right. Let's see what else we have for some literary practice. This is called Dune Tune. Dune as in, looks like a sand dune. Ready? Here we go. You climb nearly 500 feet to the top of the desert dunes. Pausing to catch your breath, you survey this sandy southwestern corner of the 1.6 million acre Mojave National Preserve before racing back down the steep hill, waves of sand washing over your feet. Then you hear it, a low rumble that's a cross between a whale's underwater moan and the thumping of a jet taking off. This is the song of Kelso Dunes, a remote but popular attraction about 200 miles northeast of Los Angeles off Interstate 40 that draws visitors for its serenity as well as its sonority. The sound is generated when the sand grains rub together, says Linda Slater, Chief of Interpretation at the park. When you get a lot of sand moving, that's when it makes the best boom. There is no entrance fee to the dunes. The trailhead is 3 miles west of Kelbaker Road on Kelso Dunes Road. The restored 1924 Kelso Depot Visitor Center open 9 a.m. to 5 p.m. Friday to Tuesday. 11 miles north of the dunes, has exhibits and park information. All right, let's practice a little from this stipulation. Ready? Here we go. In 1 second, let me put a stipulation on the record, and that is this. The parties stipulate that Ms. West's testimony will be transcribed by our court reporter. She will thereafter be relieved of her custodial obligations under the code, that Ms. West may sign the transcript under the penalty of perjury, that the original of the transcript of the deposition be forwarded directly to Ms. West at her address at 514 Rose Drive, Barstow, California, 91541. She will have 30 days to review the transcript. I'll request our court reporter put a self-addressed stamped envelope to my office. I will thereafter keep custody of the original of the transcript. If there are any changes to the transcript, I will notify counsel within 10 days of my receipt of the deposition. I'll also keep custody of the original as well as the exhibits of the deposition. If for any reason the original of the transcript or of the exhibits or either are lost, destroyed, or for any reason unavailable, a certified copy from our court reporter may be used for any purpose during the pendency of the litigation. I also will agree to lodge the original of the transcript and of the exhibits on or before the first day of trial, or as requested, and make it available for reasonable inspection if need be. All right, let's get back to our jury charge. Ready? Here we go. A fact is proven by direct evidence when, for example, it is proven by witnesses who testify to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case. For example, the fact that a person walked in the snow could be proved by an eyewitness who testified directly that he or she saw a person walking in the snow, or it could be proved by circumstantial evidence of shoe prints in the snow, from which it can be indirectly inferred that a person had walked in the snow. During this trial, I have ruled on objections to certain testimony and exhibits. You must not concern yourself with the reasons for the rulings, since they are controlled by rules of law. By receiving evidence to which objection was made, I did not intend to indicate the weight to be given such evidence. You are not to speculate as to possible answers to questions which I did not require to be answered. You are to disregard all evidence which I have ordered stricken, or have told you to disregard. You must consider these instructions as a whole and regard each instruction in the light of all the others. The order in which the instructions are given is of no significance. You are free to consider the issues in any order you wish. You have been allowed to take notes during the trial. You may take these notes with you to the jury room. You should not consider these notes binding or conclusive, whether they are your notes or those of another juror. The notes should be used as an aid to your memory and not as a substitute for it. It is your recollection of the evidence that should control. You should disregard anything contrary to your recollection that may appear from your own notes or those of another juror. You should not give greater weight to a particular piece of evidence solely because it is referred to in a note taken by a juror. During these instructions, I may define certain words and phrases. If so, you are to use those definitions in your deliberations. If I have not defined a word or phrase, you should apply the common, ordinary meaning of that word or phrase. Attorneys are officers of the court. It is their duty to make such objections as they deem proper and to argue fully their client's cause. However, the arguments or other remarks of an attorney are not evidence in this case. If the attorneys have made, or if I have made or should make any statement as to what the evidence is, which differs from your recollection of the evidence, then you should disregard the statement and rely solely on your own memory. If an attorney's argument contains any statement of the law which differs from the law which I give you, you should disregard the statement. All right, let's try a little more literary practice. This is called building trust. Ready? Here we go. Whenever a natural disaster strikes, whether it's hail, earthquake, or wildfire, contractors will rush to the affected area to offer their services in repairing damaged homes. Most are trustworthy. Others, however, may be con artists intent on swindling often desperate homeowners out of their disaster relief checks and insurance settlements. Thus, it's important to be aware of potential scams, billing for work not performed, charging more than the going rate, or even manufacturing damage in order to collect are just a few. But if you follow a few steps, you're more likely to find a credible contractor that can get your house back in shape. Call your insurance company. Find out if claims arising from your particular natural disaster are covered by your homeowner's policy. When it's safe to do so, visually assess your home and take photos if possible. Then call your insurer. Your agent will help guide you through all the claims process. Get recommendations. Talk to neighbors, friends, and relatives who've had work done. Ask your insurance agent for a few names. Most insurers maintain a list of approved contractors, or look up local contractors on the National Association of State Contractors Licensing Agencies website. Perform your due diligence just as you would with any home repair. Get more than one estimate. Before making a final hiring decision, check with the local Better Business Bureau and/or Home Builders Association to see if any complaints have been lodged against your chosen contractor. All right, we will stop there, and that will conclude our literary and jury charge practice.